Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everybody in between. My name is Dan Balkaran, and I'm going to be your employment lawyer. Oh, there you go. There's my name on the screen. I'm going to be your employment lawyer for the next 30 minutes or so, answering all your questions about all things employment law. As you can see on the screen, I'm a lawyer at Samfiru, Tumarkin, LLP, which, as always, is Canada's leading employee side employment law firm. Okay, housekeeping before we get started. If you need to reach us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, I have a few questions here. Please, we have a short amount of time. If you could send them in, I'd like to try to get through all of them before the end of the broadcast if we can. So send them in as soon as you can. Okay. JR asks, I've been with my company since 2011 in an engineering role. In 2024, under new management, I was sidelined, reassigned to a senior engineering role, sidelined, reassigned to junior tasks, and eventually suspended on June 25, 2025 without notice or explanation. I filed a WorkSafe BC claim, and requested clarification from Human Resources, but received no formal response. So I mean, there's no question there, JR, but I suspect what you're asking is, what can I do about this? So generally speaking, if your employer breaches a fundamental term of your employment, you have a finite window, up to 2 months, sometimes 3 months, and there's no real firm line on when, but there have been acceptance of saying that you've rejecting the breach will say up to about 3 months in BC on at least one case, 2 months Supreme Court of Canada rejecting the change. So when they took you from senior engineering to junior tasks, now I assume your pay and your title didn't change. It's just that what you were working on was hollowed out a little bit. It was substantially less than what you had been working on. So that can be a demotion in kind. So you're not actually demoted. It's just that your duties are hollowed out. And so the law recognizes that there's more to a job, more to your career than simply money and a paycheck. There's an element of individual satisfaction, personal satisfaction, and identity tied up with what it is that you do. And so if your position has been hollowed out, even though you technically haven't been demoted or your pay hasn't been cut, it can be what's called a constructive dismissal. The actions of the employer are tantamount to a termination, but it is up to you to accept that. Put it better. Actually, that's not a good way to say it. It's up to you to say, employer, you have breached a fundamental term of my employment, and I reject that, and therefore I've been terminated. Okay. Now, it's very important. You should not do that without the advice of a lawyer. They're too complicated, and it's not something that I can give general, or any lawyer can give general cookie cutter advice on. That you have to get specific, tailored legal advice on your situation. But nonetheless, when they did this in 2024, you may have had the ability to trigger your constructive dismissal. Well, why would you do that? Well, the reason why you do that is if by triggering your termination, you had an entitlement to, well, let's just say you don't want to work there anymore after this. You want to, and you have an entitlement to a decent amount of severance, reasonable, and a large amount of severance. You've been with the company since 2011. You're a senior engineer. It depends on what your employment contract says, but depending on what that says, and then your age, length of service, and position, you can get as much as 24 months from severance, which can be, quite a bit of money. So, but you can also not. It just depends on those factors that I mentioned. And so you need to speak to a lawyer first before you ever consider pulling the trigger on a constructive dismissal. I've talked to many employees over the years who've threatened constructive dismissal, not knowing what it is properly, and that can be problematic. So you don't want to ever try this kind of thing on your own. However, without the benefit of legal advice. So anyway, that all happened in 2024, and you didn't pull the trigger on your constructive dismissal. So you're deemed to have accepted the reduction in your role after about 3 months. Like, you can't go back 6 months later and say, hey, you reduced my role, that's a termination. Well, maybe it was, but you accepted it with the passage of time, generally speaking. So you have a short window to do it. And it's it's a tough one in law for employees, because you're effectively ending your own employment. And if a court doesn't go with you on the fact that it was a fundamental breach or a breach of a fundamental term of your employment, you basically just quit. It's a constructive dismissals are challenging, and I'll say that the hardest ones, or almost the hardest ones, are the reduction of your role. Not even a demotion, but where your pay and position remain the same, but your actual duties have been substantially reduced. That's really hard, because you have to convince a judge that, if that judge was in your shoes, that he or she could not continue to work in that role. It's certainly possible, but it can be challenging. Anyway, you're suspended on June 25th, 2025 without notice or explanation. That's very unusual. Do they provide you a suspension letter or anything like that? What does your record of employment say? If they issued you one, which they might not have, so, I mean, unless your contract says there's a right of suspension, they can't suspend you, and you could claim constructive dismissal most likely then. But again, the core of any employment relationship is that you're exchanging money. That they're exchanging money for your labor across time indefinitely. Okay, and so if you stop giving them labor, the relationship's at an end. You quit. If they stop paying you money, the relationship's at an end. They've effectively terminated you. Okay, and so if they've suspended you with pay, that's different. But if it's without pay, you again may have a constructive dismissal. If it's with pay, you may also have under constructive dismissal, there's a second, much more difficult branch called repudiation, where if the employer indicates through its actions it just doesn't want to employ you anymore, then it may also have constructively dismissed you. Think of it as like a death by 1,000 cuts, or in this case, a termination by 1,000 cuts. Those are tough to get to. You'd want a lawyer to look at that very carefully. I don't know why you filed a WorkSafe BC complaint unless there was, some sort of harassment or bullying component to it, or a safety component. But JR, I would talk to an employment lawyer right away. If you want to talk to us, you can do so. Employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. And I'll just say, JR, that what I've talked about is generalities. There's a lot missing from, you sent in 2 paragraphs. It's very hard to understand what's going on, and there is no substitute for specific, tailored legal advice tailored to your situation. So I very much encourage you to get a legal advice right away. Question from Jimmy. I recently started a new position as a salesperson, and my contract outlines my commission being based off of gross sales. After working for a few months, my employer is saying that is not correct. My commission structure is quite different. Is there anything I can do about this, or do I just have to accept it? The amount I would earn would be very different as a result. That's really interesting. So I'll just say this: there is a perennial battle between business owners and commission employees to, I'd say there's an element of incentivizing employment through promised commission that either doesn't materialize, or when the employee does too well, the commission is too high, the employer wants to reduce that commission across time. And it's that reduction that's always a battle. And so, I just talked extensively about constructive dismissal in, the case of a demotion or a hollowing out of position. Where I see it most frequently, or almost most frequently in terms of constructive dismissal, is where you have a commissioned employee where the employer says, this is a new commission agreement, this is what we're going to pay you, and the reduction is significant enough that it triggers, if it's about 20% of your pay or more, or if it's less than that, but it's paired with other things like a loss of prestige or demotion or something, then it can be a constructive dismissal as well. Quite often, it doesn't get to that 20% mark, or at least a mark substantial enough to trigger a constructive dismissal. Yours is a little different. Yours is, here's what we're going to pay you. Oh, actually, that's wrong. And now that you're a signed up employee, here's what we're going to pay you. Now, if the amount on the difference between the two is 20%, I mean, this is BC again. I mean, it's more or less the same in every province, I believe. 20% is a good rule of thumb. It could be less in other places. Usually if it's less than 20% in terms of pay reduction and it's paired with another, issue like demotion, loss of prestige, etc., it can trigger constructive dismissal as well. But your severance, if you have an entitlement to it, because I don't know what's in we'll call it big severance. I don't know what your contract says, your employment contract. It's going to be fairly limited. It's probably going to top out at around 3 months, maybe slightly more, but certainly it could be less because you've been there for a very short period of time. Do you really want to do that? Is the amount of pay they're actually going to pay you, is that sufficient, or do you want to keep looking for a new job? Do you want to get a new job? I mean, you don't have any real time capital invested there, and so I don't know what the market is like in your industry, and if it was tough to find this job, but certainly you could keep looking while working there. Depending on the province you're in, I think that there's potentially a remedy that could get you a lot more money, at least in British Columbia, if that's where you are, for misrepresentation through the in BC through the BC Employment Standards Act. I don't know what jurisdiction you are in, Jimmy. If you are in BC, actually, if the moderator could put my contact information on the screen, Jimmy, if you're in BC, please reach out to me. I wouldn't mind talking to you about that one because it's very interesting. There's my QR code on the top there. There may be an interesting remedy for you. If you're not in BC, then I don't know if that remedy exists in other provinces. But nonetheless, you may wish to talk to an employment lawyer. I'd say generally speaking, there's not much of a remedy for you in terms of it being worth your while monetarily, except for the unique one that I'm saying might exist if you are in BC, because your employer clearly misrepresented. It promised you X, but it lied, and it's actually going to pay you Y, and you signed up for X, and so that's I certainly think there's a possible path for substantial restitution through the BC Employment Standards Act if you're a BC employee. So reach out to me if you are in BC. JR is back. Like advice on whether I should return to work if cleared. Sorry. JR is the one who was suspended and says that he doesn't know why. If he should return to work, he wants to know she wants to know if she should return to work if cleared, given the manager's involvement. I don't know what that refers to. And 2, severance options if you choose to resign. If you resign, you don't have severance options. If you resign, you get 0. Okay, so you can't resign. Circling back to what I said earlier, you should get legal advice, specific tailored legal advice. And number 3, whether I can pursue a constructive dismissal now while the investigation is still pending. I think that's a tough question. It's tougher if you're suspended with pay. So you didn't say that, but certainly it's something you have to consider. But what are they investigating? They haven't told you what you allegedly did. They haven't asked for your side of the story. I've seen that before recently, but it's unusual. Because generally speaking, if the employer doesn't say, "Hey, JR, you're accused of this. What do you have to say about it?" It's if they're trying to get rid of you for cause, it's generally not going to be upheld if your side of, you don't get a chance to tell your side of the story, depending on what you allegedly did, of course. Burton asks, my employer has recently started asking all of us to start monitoring our mailboxes after hours to handle clients. Should we expect any sort of compensation for this? Can they require this for us? I thought we had a right to disconnect. I can't recall. I believe in certain provinces you do. I think even my province does. I think there was great fanfare about that, but I can't recall. I'm a little fuzzy on this. If that does exist, I don't think there are any remedies for it, which is why, it's not front and center for me. As a lawyer, generally speaking, I deal with, what's the civil wrong and what's the remedy. I don't know. So the short answer here is, if there is no remedy, you can say no, and what impact will that have on your job, your long-term outlook there. You're not going to be well received or regarded by your employer, but they're also asking you to work during private time that they're not paying you for, right? If you say, hey, you need to pay me for this time, that could be something that also leads to the same issue. If you are doing extra work, you could always file what you're not being paid overtime for. You could always file an Employment Standards Branch complaint. And sorry, the name of the Employment Standards entity that exists in your province will have different names. In BC, it's called Employment Standards Branch, but it's called something else in different provinces. But you could always bring a complaint for unpaid overtime to that entity. But again, same thing. It's probably going to put your job in jeopardy long term. And so the question you need to answer is, how much actual work is the employer asking you to do here, right? Like, is this something that's going to take up 3 hours of your time every night, or is this going to be 35 seconds, right? And then based on that, can you, is it something you can live with? Are they going to hold you accountable for it? Like, if you don't check your email one evening, is it a problem? What's your position? Are you a management position or a rank and file employee? Are you an architect in a firm of architects? In which case, yeah, probably that's something you're going to want to do. Or is this a customer service job in a call center? So you need to ask all these questions and figure out if it makes sense for you to rock the boat somewhat within the four corners of the job. How much do you like the job? Does it pay you well? Does it pay you more than you can make on the open market? What is the open market in terms of employment doing right now? Is it easy for you to replace this job? Is it going to be very difficult? You got to factor in all of these things before you make an election on it. But can theoretically, if you're a non-management employee, can your employer ask you to do this? No. But if you push back on it, what are the consequences, and are they consequences that, potential consequences that you can live with? So you've got to answer these questions. And is there a real legal remedy for you here? I mean, there is if you're working substantial overtime, but again, the remedy would be small in terms of money, but the consequences to your employment could be substantial. So you got to think about all those things and then make a decision. Sherry asks, I recently filed a human rights complaint against my previous employer. What is the current wait times for the HRTO mandated mediation to be scheduled? I don't practice in Ontario, so I don't know the answer to that question. I don't know how. I know that court claims can also have human rights complaints in Ontario attached to them or as part of the court claim, whereas in BC, for example, it's a totally separate jurisdiction. I know that in British Columbia, and I know that's not your question, but just generally, because for most human rights complaints, there's no financial barrier to entry. So if you file a lawsuit, it's going to cost you, a certain amount of money, $200 in BC, maybe more or less in other jurisdictions, but that prevents people to some degree from filing, frivolous or unmeritorious lawsuits to an extent. Most human rights regimes, if you want to file a human rights complaint in order to preserve access to justice, which is a government choice, there's no barrier to filing. There's no fee. You can file a human rights complaint in BC for free. I think it's the case in other jurisdictions. I'm open to being incorrect, but I believe that's the case. And so what that tends to lead to is a substantial amount of human rights complaints. And so in BC, to get your matter adjudicated, that's different than a mediation, but to get it adjudicated is, it's taken 4 or 5 years. It's a substantial amount of time. That's by the Human Rights Tribunal's own estimates. So it's pretty lengthy. Notwithstanding that, you might be able to get a mediation in a year or a year and a half. I have no idea what it is in Ontario's Human Rights Tribunal. But you may be able to call them and ask. T asks, I was recently fired for my internet usage in the office. I sometimes put on a YouTube video to listen to while at work. There's nothing in my employment contract about this. I'm sure other employees are doing the same. Can they fire me for this? Is it enough to claim cause? Yeah, I mean, if you're listening to music in the background while you're working, I mean, the issue is, were you engaging in time theft by playing on the internet instead of working on your tasks, right? And they say, well, we looked at your internet usage and you had an 8-hour shift, and for 7 hours of that day, you were watching internet videos all day, but they don't go into what you were actually looking at. And so if they fired you for just cause, they have the burden of proof. The employer has to prove that your misconduct, A, that you committed the actions that they said you committed, and B, that in committing those actions, that the relationship of trust between the parties is forever sundered and can't be repaired. And that's and that their remedy or their action in terminating you and not paying you any severance, which is paying you zero, is the capital punishment of employment law. That was proportional to what you did. And I think a full answer in defense to that is, yeah, I was still working the whole time. I just had music on in the background through internet videos. I remember before I was a lawyer, many, many years ago, I used to work in the internet industry, and we'd stream music all day long in the back, where I would, and play it for the department that I worked in, which was a technical service team. Not an issue, but it depends on what you were doing. Are you sure it was only videos, or were you doing other things? So if they start pulling your history and going through it, is it just going to be that? I mean, most people don't have just that on their work computers, so it's a mix. But time theft, generally speaking, it's a higher bar. They have to show that what you were doing was palpably outside of the reasonable scope of your the daily tasks of your work, and also outside of what was condoned by everyone else. Like, if everyone else is on Facebook for an hour during lunch, it's going to be a problem, and as long as the company is aware of it and didn't take action. So if what you're saying is accurate, I don't think they have cause, and you should certainly talk to an employment lawyer. And again, it depends on what your employment contract says, how long you've been there, your age, position. But if you were there for a little, quite a while, or at least more than a year, kind of thing, and your contract doesn't limit you, I think you have a good claim. I mean, I don't have anything specific, but that's certainly something. If you could convince me that that's all you were looking at, or all that you had going on in the background, I would certainly probably be willing to take you on as a client. So I would talk to an employment lawyer right away. I'll give you all the information at the end of the broadcast. You can see some of it on the screen now. But for the actual pure cause claim, I mean, if that's what you're doing, I don't think that's enough now. Really, the core of it is, were you working through that entire period of time, or were you playing on the internet? And if the answer is you were working, I think that's a full answer in defense. Okay. I don't know who this person is. I'm on LTD with my company since 2022. I received a letter in the mail dated July 15, 2025. This letter is asking for a written response confirming whether I expect to return to work. They have given me a deadline of July 31st. I have stage 5 kidney to respond. I have stage 5 kidney disease and I'm on dialysis and the condition is deteriorating. I will not be returning to work. I will not be returning indefinitely. Can they ask this? Yeah. So first of all, I'm sorry to hear about your kidney disease and that it's deteriorating, and I wish you the best of health and good luck and success with it. I hope it goes as well as it can go. I've had more than one client with serious kidney disease, and I know how serious it can be. If you can never work again, then you've already been out of work for 2.5 years. Okay. Sorry. Yeah, that's right. 2.5 years. They have said, so there's something called frustration of contract. And what frustration of contract is where your ability to perform your obligations under the contract of employment is interrupted, or it's stopped permanently due to a condition or due to a third party or outside event outside of the control of both parties. Okay, so quite often, or most often, it happens in the case like yours of a medical issue. And when it happens, because it's an event beyond anyone's control, both parties are relieved of all of their obligations under any sort of employment contract. What that means is, if there is frustration of contract, they don't owe you any money, and your employment is effectively extinguished forever. Okay, and so to get to frustration of contract, the employer needs 2 years. They've got 2.5 where you're not working, and no prospect of return in a reasonable amount of time. Both of those exist here. Okay, and you are certain that you're not going to return to work. So I would say this is probably going to be frustration of contract. If you can't return to work indefinitely, I think that relationship is done. Right now, you can have a conversation with them about maybe they'll pay you out your employment standards or something, but I seriously doubt the employer is going to pay you any significant money given that there's no prospect of you returning. So. And that means unfortunately, due to your illness, that your employment has been frustrated. So I would still, you may want to talk to an employment lawyer specifically to get tailored legal advice, but that's just my general view of it. Okay, JR is back and just answer this last question, and then we'll get going here because we're out of time. JR says, I was suspended with pay for an investigation. I've been asking for a formal letter to tell me why I was suspended, and they haven't received any response. I don't know what I should do, as well as waiting. Yeah, I mean, you're suspended with pay. I don't think it's a constructive dismissal. They have an obligation to investigate. I don't know if this is connected to, what happened last year with your demotion. I think it would be very hard to do that absent knowing what is in the what you've been accused of. I would wait. I mean, we don't know what's going to happen. They've suspended you with pay. They're not telling you what happened. At some point, they are. They may terminate you. They may not. But I don't think it's a constructive dismissal now. No, I still think you should get tailored specific legal advice. So I'm going to give you our information right now. But just at first blush, I probably wouldn't pull the trigger on your constructive dismissal. But a lawyer that you can talk to in detail about it may think differently. So I encourage you to get individual tailored legal advice. Okay, if you want to talk to us, you can do so. Employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Thank you for all your great questions today. We got through all of them, which makes me very happy. Have a wonderful and safe weekend, and join us on Monday at 1:30 p.m. Eastern Time with Chris Justice, who will be answering all your questions about all things employment law. Have a great weekend, everybody.